we decided to have this land use working group formed, and during that formation process, we agreed to come back with some updates throughout the process. And I thought today would be a good opportunity for me to provide an update on our progress. I know you guys are watching what's happening. There's been a lot of attention and a lot of media coverage of these meetings, and countless hours of meetings, and then the behind-the-scenes work that's going into the working group's progress. And I was looking at, we formed at the beginning of the year, first quarter. Now we're in the beginning of, or mid-July at this point. We've met numerous times, and I feel like our progress and our pace has been adequate. And now I'm hopeful that we're going to land the plane, if you will, in the next couple meetings with recommendations that you are looking for. A reminder of our working group membership. We've had terrific participation from our membership. Nearly everyone in some fashion has been at the meeting or watched the meeting afterwards or logged on and appeared virtually. So that's really a positive for us, because these are basically volunteers spending countless hours of their time coming in during these meetings and then prepping for the meetings outside of our working group meetings. So a lot of appreciation for their willingness to serve. When we created the working group, the framework was developed through council feedback. These are our large goalposts, if you will, these 5 initiatives. And I think the recommendations that will come out of this work will fall under one or multiple goals that are listed here, where the recommendations are going to touch a number of these items that we're focused on. I'm sharing a couple of the slides from the last meeting that our consultants developed, just to remind you of our quarterly process and where we are to date. In the second quarter, we developed our draft recommendations, or started to develop through the conversations and feedback that we received. Quarter 3, we're going to finalize the recommendations and present those to County Council, and then I believe it's your intention to immediately turn around and take those recommendations and start working on them in the form of our ordinance process. So that's really the mission for the rest of this year. So far, I said we've met 6 times, and this is an idea of what we were discussing throughout those meetings. We generally meet for 2 hours, maybe a little longer if necessary. Before our last meeting, meeting 6, July 10th, our consultants met with each member of the working group for an hour or more to solicit their direct feedback and recommendations on items they want to see that the working group will address, and then eventually what will become our recommendations. So we're in between that July 10th and July 24th meeting 6 and 7. We are scheduled to meet next week. At the July 6th meeting, we started to see the recommendations on paper, and for the July 24th meeting, those recommendations, which we're kind of describing in headline form, are going to start to build and go into more detail, so that we'll have some real direction and action items as we work through the next 3 meetings. We do have 3 meetings on paper that we are scheduled to meet. The last meeting, meeting number 9, is if needed. It's to be determined how much progress we make in the next meeting number 7 and meeting number 8. This is something we shared with the group, sort of our diagram of how we're bringing it from lofty ideas down to details. Because ultimately, your recommendations need to be something you understand and that you can turn into, I call it an action item, which will eventually be written into an ordinance form, which, to answer the caller's question earlier, this will all have to come through a public hearing process. Whatever ordinance that you decide to move forward with will have to come through public hearings here in the form of our ordinance deliberation. So we're at the point in time where we have draft recommendations, and now we're refining those recommendations, and eventually we'll have the action items. I mentioned at the last meeting, we put forth 22 plus or minus recommendations in headline form. I do believe that list is going to consolidate a bit, because there's some items that are touching on similar thoughts that will eventually be consolidated into what will be our takeaway. And most important is making sure that we put some depth to these recommendations so that you understand what the group is asking for you to consider, and also what next steps would look like. We just don't want to put something out there that says increased density in certain areas of the county. That gives you no direction. And I'm using that as an example because that's one of the things that we're really focusing on is density and where it makes sense. But you also need to take there's 10 representatives there with 10 different points of view. I think at the end we'll have that consolidated down with good recommendations that will make you understand what they're asking you to consider. So looking forward, 2 or 3 more meetings are scheduled, and then we will come back and present the recommendations to you all. I'm assuming we will probably do that in a workshop format where it's a little more comfortable. We can spend some time and analyze the recommendations and go through them with you. It's important for you to hear from the working group membership as well and hear from our consultants. And then eventually, the working group, we're going to have to prioritize the recommendations. I think there's going to be some low-hanging fruit that we can take action immediately and probably turn into an ordinance pretty quickly and run it through. Then there's going to be some recommendations that are complex. Maybe they require an element of our comp plan that we need to address. If that's the case, that's going to take more time. So it's going to be up to you to really prioritize these recommendations based on what you want to see addressed first and how fast you want to get through some of these, because not all of them are going to be equal when it comes to the time and complexity. I believe that's it. Any questions?
I have couple comments and then questions. Okay. First, I want to publicly thank the task force members. As you mentioned, Todd, they've done a lot of work, all volunteer, and not just at the meetings, but people between meetings are doing research and talking about these issues and holding conversations. So I just think we owe these people a lot. It's a really big task they've taken on. And secondly, I want to thank them for staying on time. You know, when we put this together, we specifically did not want to see this be a task force that just sort of went on, and I really, really appreciate that. Thirdly, I want to again express appreciation for the fact that recommendations are going to come to us in a form that are specific enough that we can take action on them. And the other comment I want to make is a clarifying comment, because I get these questions when I'm out talking, which is that the task force is advisory to us. They are not the ones to make the decisions, and that we will make the decisions about which, if any, of these suggestions we move forward and how we move it forward. And I just want to be clear about that.
Absolutely.
And finally, I do have a question, which may be better addressed to our attorney, and that is, what, if any, mechanism is there?
Push your microphone.
Oh, it went off. These things go off. What is that? Want to ask if what mechanisms we can look at or think about or should think about or are necessary or not to prohibit, while these ordinances, while we're working on these ordinances, one of my concerns is that a number of applications will suddenly come through come through the pipeline to get ahead of some of the changes we're going to make. So I'm concerned about how we deal with or think about that conundrum.
Sure. And we've had some brief discussions, and one of the things that came up and was discussed, and I've heard other people bring it up, was something called a pending ordinance doctrine. And we've seen, and I know that some of the municipalities in the county use those, but from what I've been able to determine, Sussex County itself has never used it. In my experience, I talked to Mr. Robertson, and he is unaware of it ever being used for the county. And what that doctrine indicates is that at a certain point when the county is getting ready to do something, that it would be inequitable for someone to be able to go file something quickly, get it across the counter, for example, and basically thwart what the intention of the proposed ordinance is. And in looking at that and looking at some of the cases concerning that, they tend to be more the type of issues where you could go in and get a building permit across the counter. For example, what the proposals would be to change, for example, a setback line, and someone rushes in and gets a building permit quickly. That's something can be done easily. Or if you were putting a moratorium on no more billboards and you run and file a quick application to get that, those kind of things are more applicable for that case. But in our case, and the second part of notice, looking at some of the cases, there's a question, Delaware courts have not decided when that would take effect. Is it at the time that you would just bring up an ordinance, or is it sometime during the public hearing process? That's not been defined yet. The one recent case in Rehoboth, they had actually already had the public hearing and adopted the ordinance, and were able to use it. So I'm assuming that maybe the ordinance did not go into effect immediately, but had a period of time before it took effect. So in looking at that, kind of looked at the circumstances that we're faced here. We're not looking at these minor things that you can go in and get an easy building permit for. These are the type of applications, even though the application itself might be short, with all the attachments that have to go with it. Anytime that you're talking a subdivision ordinance, it takes substantial engineering, dealing with other agencies, going through with other agency reviews, and many attachments to go with that. It literally takes some months in order to get that completed. So I don't think that based on that there's anything that we're talking about here that someone could go in and shortcut the process by just filing something. I wanted to double check my information. I did talk to Mr. Whitehouse just to find out from him, am I missing something that someone could go file? And Mr. Whitehouse is here today. And if you want to come up, it's my understanding that even the application process now has been drafted in such a way as to prevent that.
Correct. If I can assist. Good morning, Mr. President, members of Council. So in the last 5 years, we've made procedural changes within the Planning and Zoning Department that affect the amount of information a major subdivision must contain before we even take it in. For example, you have to have submitted to PLUS and go through the PLUS process for all residential subdivisions of more than 50 units. You have to have, because of the changes Council made last year to Chapter 99, there are new informational requirements. So you have to have a forestry assessment. You have to have your wetland studies and supporting documentations for resource buffer management. So these are things that you cannot craft over a weekend and then decide on Friday I want to submit and apply on Monday. They take weeks and months. And the larger the development, the more complex those studies are, and the need for professional engagement. Resource buffer management plans, they require back and forth with county engineering and P&Z, and they can take months to process. So the larger the development, the longer it takes to prepare is the point that Mr. Moore's going to make. And I agree. So.
And that is even for the application to even be filed, you will not accept the application unless it has all of that. Is that correct?
That's correct. There are minimum information requirements that must be met before we even accept it onto the books.
So we have to accept it before it's considered filed?
Correct. We have to accept it at the council and say this is enough to take an application in. I think historically there have been cases of someone throwing an application form in a subdivision plan but not having all the complete information and then assembling that between submittal and public hearing. But there are processes in place now to stop that. So that it's because of the processes and requirements are in place now, we're talking about weeks, months to submit even the most simple application. The larger the application, we are talking months, multiple months. So if that assists you in understanding the timeline.
Thank
and
you.
I just want to make sure I'm 100% clear. You're not going to consider the application submitted until you've gotten the plus review back, gotten the gotten the Del Dot studies back, gotten the assessments back in the 99C, and had the paperwork and the money submitted, that is when that application is submitted.
You have to show us that it's been submitted to PLUS, not necessarily it's been heard by PLUS.
Okay.
You have to pay a fee, you have to fill an application form, and there are document requirements on the county level, like a wetlands management or resource buffer management plan. That's a very large, complex technical document. There's now a forestry assessment document that is required. That has to be available on submittal.
So, one of the examples that I remember many years ago, I'm much older than most people, been around here a good while. I remember at one point they were changing some of the ordinances on strip developments on the along roadways. And at that point, they were proposing that, well, you could just go get a surveyor, and quickly while that was being discussed, and people were cutting out 150 feet all the way down the road frontage, and that was able to be done quickly. That's not the case what we're talking about here. It does take a very substantial application. So, with this information, and it still comes back to the question, what can we do to make sure that, there's not just loads of applications in a process? What I would suggest, and I heard Mr. Lawson say that hopefully there's going to be very specific recommendations, that there's going to be multiple ones. I would argue against the one big beautiful bill in this case, that you have very specific requests if you want specific ordinances, even if you have multiple specific ordinances, so that you can move on those quickly, because the more defined they are, when you come through the public hearing process, it's much easier in your discussions without getting bogged down on other issues. And if there are amendments to be made, it's easier to define what those amendments could be. And then what you do also is make sure when you pass it to take effect immediately upon the date of passage.
Right.
So that all of that will make a big difference and prevent any applications from coming in
Right.
during that process.
Thank you. I really appreciate that and understand your point. So the major issue, if you will, would be those applications that people are that they're already working on and are close to being able to apply. The possibility that those get kind of pushed forward more quickly.
Those could, if someone's been working on it
Right. They see this coming and right.
Right.
And so the pending ordinance doctrine that you mentioned,
Yes.
and I would also in my question include moratorium. Both of those would require their own hearing process, right? If we were to apply a pending ordinance.
Now, the pending ordinance doctrine would not require any type of vote. It's something we've not used in the past, but there is case law for that, and some of the towns use it, but it's usually used on these minor type things, by building permits, for example, not the big items that we are, because the
But is there any reason to think we couldn't use them for bigger items?
There's part of my concern would be that just due to the amount of work that would go in up to it, if someone's been working for 8-10 months and ready to file, if that's the case. And I would anticipate that would be very minimal amount, because people have to already have acquired the property or the rights to the property to file, to do all that. Also, due to the fact that there is no definition at this point on when the doctrine takes effect. Is it when someone introduces an ordinance? And the other thing to always keep in mind, any one of you can introduce an ordinance at any time. Although it's been kind of our policy, let's discuss it in here first, see if there's some type of support for it. But you have the right to file an ordinance at any time. So would you, by simply filing that, prevent anyone's right to file, even though there might be 4 votes against what you're introducing? And I think that would have a very chilling effect if you had that kind of process.
I appreciate it. Thank you. we'll probably have some more questions. Sure.
Yeah.
Thank you.
It's not like we're asking to do the pending ordinance doctrine today. You know, that would be a date in the future, but eventually we're going to be looking at and passing ordinances. So the argument, if it's not appropriate to do the pending ordinance doctrine because somebody might have something in the pipeline, that there would be a set date for that. There would also be a set date for an ordinance change. And I mean, I would just be concerned about that rationale, because that's the rationale you'd use against doing any ordinance change, is there might be something in the pipeline.
No, you would still do your ordinance change. And if someone had filed before it was passed, what the kind of the goal of the pending ordinance doctrine is to make sure people don't go in and file something quickly and basically thwart the purpose of the ordinance. But the things that can be done quickly are like building permits over the counter, zoning applications that are very short to do, those kind of things that maybe a few days you could go in, file something and stop it. What you're talking about and what's coming up here is not that same type of animal. It's something that would take a lot of works in order to get it through, even start the process and get it through.
Ask
Sure.
one question, or maybe say one thing. So just to, I guess, reiterate what I think the concern is, and something that I too share, is the intent really being to capture changes that we intend to make that we are just not quite solidified on what they might be. Now, maybe it is too vague right now what the proposed recommendations are going to be. Todd mentioned there is some, potentially low-hanging fruit, but say what is being discussed right now might be 15 or so different recommendations, and maybe two meetings from now we get down to 6 more specific recommendations. 2 of those can be achieved in a quick ordinance draft, 2 public hearings at P&Z and council and approval of both, but maybe the other 4 take 10, 12 months. I mean, we've seen ordinance changes, within the last year, 2 years that have taken 12 plus months to have come to fruition. And so I think probably the intent of what we're trying to get at, and maybe it is a more expanded version of that pending ordinance doctrine, but really trying to, we came into this with a sense of urgency of making change. We are making progress. But again, really like showing that intent to capture those changes sooner rather than later. And I think I'm just envisioning an administrative sort of prioritizing or pausing of applications for certain things. We anticipate changes coming, and maybe those are accumulating on a desk at planning and zoning. Maybe they still go through the process, but before they're processed back in through our system, maybe that's where the pause or consideration for future changes. And I know what you're saying, whether it's from the date that it's been proposed versus the date that it's actually adopted. I'm no lawyer, but I have read some state cases, some state verbiage about previous cases that captured it from the date of proposal as opposed to the date of adoption. And that's something maybe we should go over, between us. But I just want to restate the intent and then outline maybe more specifically what we're trying to get at.
Yeah, I think that everyone gets your intent is that there are certain changes you want to make. You would like to get them done quickly. And so the outcome is not just making the change, but you want your outcome to change. And so as you go through the process, we can look at that.
Yes. Okay. Anything else?
I did,
Good
Ms.
go on.
Greenbaum
Go on.
Councilperson Greenbaum spoke first, but I'd like to also thank them and pretty much echo her sentiments about, I think they're doing a great job. We've got a good group of professionals from, certainly diverse interests, all in one room, volunteering their time to, affect how development looks like in Sussex County. And a lot of times it's surprising, but they're agreeing on a lot of topics. And, I'm excited and feel positive of, the outcome that we should be seeing in the very near future.
Well, thank you. I think, Mr. Lawson, you have one more item.
Yes, sir. Wrapping up with the County Administrator's Report for July 15, 2025. Item 1, per the attached engineer